Hello.
Hello. Hi, Maria.
Ist heute keine Vorlesung?
Doch,
Okay.
und der Mitstreiter.
Die kommen noch.
Ah, so, dann gucken wir mal. Bitte schön.
Danke.
Gutes Frage.
Han var det siste. Han skal ha spørretid neste uke, men den tror jeg får ikke skrive det essayet, det skriver ikke jeg. Og jeg tenker, jeg har jo hatt min eksamen, så jeg takk for meg. Ja. Greit det. Snakkes. Ha det.
Genau. Oh Gott. Wir drücken auf Fahrrad dazwischen. Ich sag nur einmal.
Die Leute sollten wahrscheinlich alles der YouTube legen. Die Leute, die gucken wollen, wissen, dass da ein das nur gestaltet was. Die meisten
Mhm. Werden alle Ausführungen.
Wenn du da mal draufklickst,
Diese schwarze Grüße.
Zum
Diese Stoff. Ich weiß, ja. Lösungskette.
wieder später.
So, hi everybody. Hi everybody in the room. So, hi everybody in the internet. First, my apologies. I have just sent the wrong link to YouTube, and I've corrected the link 2 seconds ago. So you find the original link in the last mail. The education will probably finish next week. We have the session today, which has to do with media law. And next week, a session consisting of Q&A, starting at 12:15, a quarter. So 45 minutes to discussion on essays, how to write essays, how to cope with ChatGPT, how to find a scientific approach, and your questions, whatever you want. After that, at 1 o'clock, we have a final lecture by two colleagues from the University of Deggendorf and one higher range judge on ChatGPT and the AI regulation. There's a very good lecture. I've seen it. They have written long articles in the Frankfurt Allgemeine on that topic, so it's worthwhile. So if you don't have any questions, so you're all satisfied with your notes and grades as master students? Are you satisfied?
Yes.
Everything fine? They have to finish their exam. When is the date for the Klausur?
16th.
Oh, okay. Okay. Let us go to the final lecture. It's a lecture on, it's for other EU regulations. There are two regulations. One on the Media Freedom Act. That's a new act, Act 8X, you see as a regulation. It was made in 2022, prepared and discussed, and it entered in force on the 7th of May 2024. The rules will fully apply in August next year, this year. The objective of the Media Freedom Act is to establish harmonized rules across the EU to address shortcomings in the protection of democratic principles and fundamental rights. It's a focus on strengthening the role of the media sector in shaping public opinion. And of course, as a fundamental goal, it ensures the proper functioning of the internal market for media services. What is media within the sense of the Media Freedom Act? It has a wide range of applications, including television, audiovisual, on-demand services, radio, audio broadcasts, press releases, and video sharing platforms. So the borderlines, there was always a problem as this institute between media law and platform law was very unclear. That was one of the problems of this institute. Then we had a colleague called Holznagel who was working in the other part of Berlin, and he was doing traditional media law, and it has an overlap in the area of internet. So sometimes people say, who is now responsible, Holznagel or you? That's a long problem. You see the wide scope of application. From a geographical term, when is this act applicable to non-German companies? Is not clearly defined in the act, but the act applies in any case to all media services provided or offered by providers based in the European Union. What is a media service? As a definition in Article 2, saying it's a service where the principal purpose of the service consists of providing programs of press publications under the editorial responsibility of a service provider. A service provider is defined as an official or legal person whose professional activity is to provide media service. There's another definition of a provider of a very large online platform. That means a provider that is a very large platform according to DSA. You remember the words gatekeeper in the DMA, and we have very large platforms in the DSA. Now it's used as well as a definition in the media freedom act. There's a provision saying editorial independence is protected. The actual editorial freedom of certain media service provider has to be respected, that journalistic sources are protected, and that transparency is guaranteed with regard to the ownership structure. There was a feeling in France that the French police forces said we need to spy on media. So we have to be aware what these damn journalists are doing. They are dangerous to the state. A little bit like Georgia. So the state wanted to use spy tools to investigate into internal structure, but that has been clearly prohibited. So no spyware against media, including journalists and their families, that's strongly prohibited. There should be guaranteed a stable funding for public service media. So the appointment of directors and board members of public service media must be transparent, open, and non-discriminatory. As a general concern, public service media service as defined should present a variety of information and informations in impartial manner in accordance with their public service mandate. That leads to the question of financing, because the new act provides for adequate, sustainable, and predictable financing of public service providers. The impact of media market concentrations on media pluralism must be assessed. So any way of controlling market concentration processes should be open and discussed in the public, should be justified and proportionate. Next is a typical Austrian word. You know a little about the Austrian press. They got a lot of money from the state. So the state said, we pay for any advertisement, we need a lot of money, so we can control you. So you are well paid. This advertising revenue from state needs to be disclosed. Any act of government advertising should be discussed in public. The transparency and objectivity of the audience measurement system that affect media advertisers and owners has to be improved. There needs to be a safeguard system against the unjustified removal of media content. Again, a problem you face in Georgia quite often, that sometimes the news are away. It's simply taken out of the internet system. What is happening here? Yesterday we had the news, today it's gone. So that's impossible. So very large platforms must inform the media service providers of the reasons before such a removal takes effect. there was an establishment of a new user right to customize the media offering on devices and interfaces, not such as networks, TV. So the users are allowed to change the default settings so that they don't see only the state TV with the chance to freely decide about what can be seen if you type in ARD or ZDF on your TV. And again, bureaucracy in Europe is of course well established. A new supervisory body, the European Board for Media Services, has to be created. This board acts independent and advises and supports the Commission in applying the Act. So the member states still have some time to adapt their provision until August this year. There was always criticism from Austria because Austria and France said, why does the European Commission has a right to control media regulation? Because media regulation is only local regulation, it's not a task of the European Union to establish rules. So there was also protest from Germany, for instance, a powerful Springer press said the Commission hasn't any competence for media law and it should be a directive instead of a regulation. Even the German Federal Council, the Bundesrat, criticized the effect that the European Commission is missing the competence. There's another regulation. One was the European Media Act, and then is SLAPP and AntiSLAPP. Have you heard about SLAPP? SLAPP means strategic lawsuits against public participation. You don't understand what it is. It has to do with a powerful big player which are threatening journalists, for instance, in civil courts. Take an example from Great Britain. Two small journalists wanted to publish a study showing that McDonald's has not really controlled the food recipes in McDonald's food. When that became known, McDonald's threatened to bring a suit in court with a damage of 30 million British pounds. 30 million British pounds is far more than the Germans had. So the way of misusing civil law cases for publishing and for sanctioning journalists. So the journalists in Europe made a common paper called AntiSLAPP, showing strategies for prohibiting the big companies from this thing. The proposal was made in 2022. It was now a directive made in 2024, and it must be implemented in the member states by next year. Astonishingly, very astonishingly, the German legislator, the Bundesregierung, has made the first draft on AntiSLAPP. So they are just starting to work, and they had already an AntiSLAPP draft for new act. So the European Commission wants to address the problems of stress, SLAPP, by simply prohibiting manifestly unfounded and abusive claims against participation at an early stage. The regulations are intended to apply to abusive cross-border claims. These connections is presumed unless both parties domiciled are in the same member states as the court. So it's only applicable to cross-border discussions and court claims. The regional basis is Article 1, 2, a cooperation in civil matters having cross-border implications. So, what does public participation mean? Is any statement or activity by a national or legal person expressed in the exercise of the freedom of information and freedom of expression on a matter of public interest. This is protected against big companies and their claims. If complaints of a big company is directed against such statements and are manifestly unfounded, then it should be possible to shorten the ordinary court proceedings so the defendant can apply for the earliest possible dismissal of manifestly unfounded claims. Courts should be able to demand that the plaintiff provide financial security in order to protect the defendant. The AntiSLAPP directive provides for deterrent sanctions against the parties that brought up a SLAPP action, and member states should set up central contact points that offer information and psychological help to journalists. The claimant also bears the burden of proving that the claim is not manifestly unfounded. It is only made for cross-border claims, but it was changed in the German proposal for an act. There is also applicable on a real national claim. The important term is also the word abuse. If there's an exhaustive list of indications that are abusive, in particular disclosure of proportionality, excessiveness, unreasonableness of action, the initiation of a number of parallel proceedings, the case of intimidation, harassment, or threats on the part of the plaintiff, and domestic cases are covered by the German draft. So the German draft said this domestic international that the AntiSLAPP means can be provided. So the directive has to be proposed by the 7th of May 2026 next year. The German already have and draft. And that is a proposal to change the ZPO and the Arbeitsrecht. So that might help journalists. There was a new section in 615 inserted that says there's a really high priority requirement. So if a big company is suing against journalists, the case has a high priority. At the request of the defendant, the plaintiff may be obliged to provide security for the legal costs. Legal costs incurred by the defendant should also in the future be reimbursable in excess of the statutory period. An example from Germany, when journalists wanted to to publish a report on RWE power, he was prosecuted under civil law with a claim of compensation of 2 million euros. And that is a clear anti-SLAPP activity. Because in the present, this RWE case has an extreme influence of power and disproportionate high demand, an attack on the press, and a thematic focus on a topic of public interest here, climate change. So this is the last slide of all slides of one year. There's still a question missing. You have noticed that we have so many regulations that sometimes you're losing oversight. You don't know where you are. So we have, for instance, 6 difficult regulations on the obligation to notify authorities. So if you notify the DSA, DMA, and the DGA, and the AIA, who has the oversight? What is the structure behind that one? We don't have a clear guideline on the general civil law for data. We need a data civil law. Now, how can you give data away? And how can you delete data? The question of data quality is the topic for doctoral thesis here. So if you want to write a doctoral thesis, please have in mind data quality, because it's often mentioned in several acts, but nobody knows what is it. So we don't have a clear coordination between various regulations, and the biggest open question is data ownership. Who is owner? Who is responsible for certain data? That remains the question. So that's all. After I checked yesterday, after 480 slides, I hope you've learned anything, and your wizards, perhaps writing a doctoral thesis would be nice. Next year, in October, we start LDA2. We are just preparing marketing for LDA2, and perhaps you want to join with us again. I thank you all. It was a pleasure to see you all, especially in the room, but as well on Zoom and YouTube. We see each other next week on the Q&A session, and with the last external lecture on ChatGPT and the AI Act. Thank you very much.
Okay, thank you, sir. Bye-bye.
Thank you, Professor Hörn. Bye.
Bye. Bye bye.
Ja.